Your case, their case. Conducting discovery when you're sued for debt. Brought to you by Kenneth Chabert at yourlegallegup.com. Your advantage if you're being sued by debt collectors. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. In considering the materials for the motion to compel video, it occurred to me that there could be a line between your case and their case that would be worth exploring. And specifically what brought this up was the discussion of the chain of title of the debt, or your justification for obtaining all the information possible about every company that has owned the debt that this one is suing you for. So let's recap what they must typically show if they want to make you pay on a debt. The debt collector has to show that it owns the right to sue you. Since it's a debt collector and by definition didn't lend you the money, that means they got to show you that they bought the debt from someone who has a right to sell it, who got that right from someone who had a right to sell it. Break any link of that chain and the right to sue you isn't there. And originally you had to borrow the money in the first place. They have to prove it all. They have to show that nothing has happened to prevent or change their owning of the debt. And they have to show that you owe the money, or another way of putting it is that they must show that you, 1, incurred the debt, that's borrowed the money, and 2, have not paid it back. Some of these things could get taken for granted that shouldn't be. You may want to make sure that they become issues. For example, the getting and retention of the right to collect the debt. You need to see the deal that supposedly created the debt in the first place. And then you need to see the transaction that gave the debt collector the right to pursue you. The whole thing, not just the bill of sale, which they love to show. What is the extent of that right? Did they get to collect all of the debt, or just some part of it? You've heard about condos and people selling various parts, rent to own or various other real estate deals. Well, the original creditor can sell the right to collect the first 50% of the debt, but not the rest. And that would make the debt collector not the true party in interest for everything above 50% of the debt. Just for one example, I don't know how many debt collectors use that arrangement, but I do know that a bunch of debt collectors are buying debt on a recourse basis. And that means that if the person they're trying to collect the debt from doesn't pay, the debt reverts or goes back to the original creditor. This could make the original creditor the owner of the debt rather than the debt collector. And that in turn would mean that the case filed against you by the debt collector should be dismissed, and your right to sue them under the FDCPA would be established. You need that sales contract to find out. Or let's consider the various owners of these debts. You know by now that the debt sale business is a very big business, and debts are often bought and sold in large quantity. And they are also resold, so it's very possible that your debt has been owned by several companies, even without you knowing it. So aside from this raising very important issues for you of who actually owns your debt, which I emphasize is crucial for you to pursue like a hound from hell, because if you let the wrong person sue you, you'll still be liable to the person who really does have the right to sue you. But aside from that question, you must also consider payments. Have you made any, and to whom? And have they been properly credited? You might think you should be the one who would know that, but they have to prove the amount of the debt, and that means you can ask questions on discovery about it to test the strength of their case and to see whether they have any information to counter whatever your testimony may be. And it is also very frequent that people make payments on accounts without knowing which account it was, and that's because the debt collectors are often not clear about this at all. You may have made a lot of payments on this that you don't even know about. So you raise the issue from the point of view of your case. What can they dispute about what you might say? And also from the point of view of their case. What can they actually prove about the size of the debt? Because remember, they have to show what the size of the debt is and that you haven't paid it. Why am I drawing such a distinction between their case and your case? Because I don't want you thinking that because you can't remember having made a payment on the debt, that you necessarily never did. And whether or not you did, the debt collector has to show how much money is owed as part of their case. If it can't do that, you will win regardless of what you can show. So to put it into something like legalese, you can defeat their case either by proving that they were wrong and you don't owe the money, or proving that they can't prove their case. That's a real distinction. It means that if there's no evidence at all, which is often the case in debt law cases, you should win. You want to be able to prove they don't have the evidence if you can. You get that proof from discovery, when they say they don't have responsive documents or information. Of course they know that, and that's why they'll object so much, to cover up what they don't have. And that's also why you have to force them to answer by using your motion to compel. See how you can attack their case by arguing that there is no debt at all and that they can't actually prove a debt? You can say that they didn't buy the debt and that they can't show that they still own it. The big weakness in these cases, because debt is sold and bought so much, is that there is often very little or no evidence. And you may be thinking, how can I prove, whatever? And that's a good question. But equally important is the question of, how much can they prove? Or how can they prove something? Or can I show that they can't prove it? That's very powerful in cases like this because of the burden of proof. That's on them. If there isn't any real evidence properly before the court to support their case, you should win even if you have no evidence of your own. And properly before the court is extremely important here. There are computer records which cannot be linked by someone at the original creditor to the actual transaction or to the companies that owned the debt afterwards. All of them are not properly before the court. They aren't records at all unless someone from the original creditor or from the other owners of the debt can say that they're good, at least as to the extent that those companies owned them. We'll get to questions of evidence later, though. But remember that if the debt has been sold more than once, that chain has to go all the way back through each debt buyer, all the way to the original creditor. Someone's got to account for the person who owns the debt has got to account for the integrity of their records at every step, and they all have to be there. If they can't do that, the claims of the debt collector should fail. Now, it's not the same on affirmative defenses and counterclaims. In those, you have the burden of proof. And if you say that you settled the case 3 years ago with the original creditor, you're going to need to prove it. Your testimony that it happened is evidence that it did in most cases, unless the written agreement between you and the original creditor said that no part of the contract could be orally modified. But from a discovery point of view, you want to be asking the debt collector about whether they know anything about such a contract, an agreement to settle the claim, because you want to make sure they don't have any evidence that you're not telling the truth. Consider every document request you make and every interrogatory you give the other side, both in terms of their case and in terms of your case. One thing I don't often mention is the statutory penalty of the FDCPA. It's a punishment for the debt collector breaking the law. How much the debt collector should get punished is often determined by how much they've done the same thing in the past, whether anyone's ever complained about it or sued them for it, and how much thought the company has put into what they're doing. Now, that's why you can ask those kinds of questions of the debt collector in the discovery. Don't forget about that while you're defending yourself from them. You want to make your case against them stick too. Remember the burden of proof. If they can't generate enough evidence to support their claim, it doesn't matter what you can show. You'll win as regards their claim. But the opposite is also true. If you can't show evidence to support your claims against them, you'll lose, regardless of what they can show. Luckily, your claim will likely be part of the legal process where the evidence will be very straightforward, i.e., It'll depend on what they sent to you, or what they've said to you in the debt collection process. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forms, and defend yourself from the debt collectors.